Item number 5, my lord, I am appearing for the appellant, my lord. I have served the copy to the other side. Lordship, this is an
On behalf of the respondent,
my lord, this is an appeal, my lord, against the order dated 31/7/2024, my lord. My lord will find the impugned order at page number 18. My lord, I'll first give the brief of the case, your lordship.
Yes, we went to the papers.
Lordship.
Mr. Samim,
yes, my lord.
the legal principle which you have argued, which has been accepted by the learned single bench, is in our prima facie view correct. A sanctioned vacancy cannot be filled up by contractual appointees.
Yes, my lord.
That is settled legal principle. Nobody can quarrel. Nobody can contest your, claim that it needs to be filled up by promotion or a recruitment process has to be commenced. That is one part of the. So therefore, the learned single bench has granted an order of stay of both the notifications. But whatever has been done thus far, he has protected, saying that it will be subject to the outcome of the writ petition. No equities can be claimed by them, but they need to be implemented or anything. We can see later. But I am on a slightly larger issue.
Yes, my lord.
You know about North Chowbis Pargana, the district is a very huge district.
Yes, my lord. No doubt.
Those two are both South Chowbis and North Chowbis. The area is so scattered, number one. All judges are suffering in the sense they do not even have a group D to get the case files. So, as rightly noted by the learned single bench, 64,12,032 has
Yes.
been spent for the financial year 2022-23 for employing unskilled employees, peons alone.
Yes, my lord.
So, as an officer of the court, as
Yes,
a
ma'am.
person who's very vociferous in all your public interest litigations, etc.
No, my lord. I am
You come
mostly
forward.
into the writ petition.
You come forward with a solution.
Yes,
Your
my lord.
employees association is right, but one thing we have to accept, which our Siddiqui learned down pleader also will accept, that appointment on contractual basis has become the order of the day in the state of West Bengal.
Yes.
Our state legal services authority has got people on daily wages for 23 years. Our Badli workers are working for 24 years.
Yes.
Nowhere in the country it is like that, sir. Now, if suppose our group, now Group D recruitment is going to start. You see the Badli workers, you ask, what is his name, sir? Secretary General says, Sumit Bhattacharya. When the Honorable Chief
Yes,
Minister
yes.
visited the
High Court Karmachari Samiti.
when the Honorable Chief Minister visited the High Court during my swearing-in ceremony, they gave representation. Now, up to 60 years of age, Mr. Samim, you won't believe it, their last take-home pay is 26,000 to 32,000 rupees per month. For 25 years, 26 years, nowhere in the country it is like this, sir.
Yes, my lord.
Nowhere it is like this. Please, what to do? Now, you are, as officer of court, you are not the advocate for employees association. You are officer of the court. The district judge cannot function, sir. Mr. Sudip Tode is the present district judge. So much of trouble. In fact, you asked earlier also, our Madam Registrar Administration, Nobunita Re, Madam, she was a district judge. Just prior to Sudip Tode, Mr. Avanipal Singh, who is the director of the Judicial Academy, he was district judge. I have visited the district. So very difficult, sir. You go to the district court complex.
I know, my lord. I
don't want you go to subdivision. I don't want you go to further. You go to the district court complex. My goodness, they are suffering like anything. One fellow comes at 6 a.m. in the morning, works till 12 in the midnight. Once again, morning 6 a.m. And what he is given 14,000 rupees per month. They'll die, sir. You give all right, stay alone is granted. We can ask them to file the affidavit in opposition. State government has to file. The state government is the answering respondent. This man, what is it, district judge,
District Judge, Lordship.
He has filed the appeal because he doesn't know what to do.
Yes, but
Lordship,
the
only
solution,
one.
may I, my lord, give a pragmatic solution, my lord?
If I may indicate
No,
only
actually-
one point, Your Lordship.
Yes, Madam,
Lordship,
yes.
that in the impugned order, Your Lordship, the notification of 28th of February, my Lord, has been stated along with another notification of 14 March. My Lord, I am not concerned with the 14 March because it is not of the District Judiciary, not 24 Parganas. My Lord, the notification of 26th of February 2024, which is the subject matter of the argument, my Lord, that notification has not been stated. And my Lord, that notification, my Lord, the entire argument has been made on the premise of that notification. My Lord, the Honorable Single Bench, my Lord, did not record and my Lord did not grant a stay upon that notification. All that we are humbly praying, Your Lordship, to kindly allow the said notification. My Lord, the notification is a
No. See,
Lordship, page
You-
number
you-
291.
no, you please come to page 10 of the order, impugned order.
Yes.
In the aforesaid facts and circumstances, no further steps can be taken in terms of the two employment
Yes.
notification, 28th February and 14th March.
Yes.
Lordship, I am talking about 26th of February, which is there at page number 294, Lordship. 26th February is nowhere mentioned. Lordship will even find the mention of the notification in their prayers also.
No. 26th
No.
February, they have not sought for quashing.
Lordship, they have sought. Lordship, it is there in their prayer, my Lord, which is at page number
You
73.
see, we are only going by the order dated 31st July. You come to
Lordship.
first page of the impugned order. This writ petition has been filed on 24th June by so-and-so association along with one authorized representative. The interest of the employees have challenged two recruitment notification, 28th February, 14th March. Therefore, the learned judge did not go into any other notification. Why
Lordship,
are you now coming by way of this appeal? You
Lordship.
proceed.
Lordship, if I kindly take page number 73. Lordship, it is their prayer. Lordship will find.
The prayer has not been granted.
Lordship, because since they have challenged this notification, my Lord, this notification
No, there
has
is
not
no
been
stay
placed.
of that notification. Huh?
My Lord, the only modification that we are seeking, my Lord, whatever.
Not with- How can we
Lordship.
modify something
Lordship.
which is not there?
Lordship. I bow down.
And with Samim, you please come forward with some solution.
My lord,
You ask your
suggest a
office bearers of the association, 3 people or 2 people, to come and meet Registrar General Madam. And
Yes.
Registrar General Madam will call our district judge and ADJ also.
Yes,
We will
my lord.
also request the Judicial Secretary, Mr. Siddhartha Kanjilal, to be present also. You do something, sir.
Yes, my lord.
This is
May I-
every day I am having hundreds of representation.
My lord, being
This association, that association. And worst, Mr. Governor Peter is here. He also should hear this. The best thing is this PWD.
May I suggest a my lord, pragmatics?
One second. Governor Peter.
Lordship.
Madam, please give way for God.
Well,
Governor Peter, what happened the other day? One set of, one group of people gave representation.
Lordship.
And who are those people? They are all daily wagers engaged by PWD contractors in the High Court premises. Shifting of case files here, there. Suddenly they will say, sweep all this corridor because function in bar association, function in bar library club, etc., etc. Those fellows gave representation. Why? They wanted minimum wages, which is their lawful right.
Yes.
What happened? That PWD contractor sensed this, that the representation has reached my secretariat. 24 people he terminated. What, to term it the least, scoundrelish act. These fellows are receiving, I think, 220 rupees per day. They want your minimum wages notification to be implemented, gave a representation to my secretariat. Even before the chapa, the ink could dry, this fellow had some sensed information and 24 people he has removed. That is one. These Badli workers' pay is so very low. And nowhere, to my knowledge, sir, to my knowledge, I've been a practitioner on the service jurisprudence for quite long before elevation, including the Central Administrative Tribunal. Nowhere in the country, to my knowledge, there is such type of contractual engagement everywhere. AMC, you go, Where is Mr. Ghosh if he is here? You ask Mr. Ghosh. Everybody is contractual. How do you fix responsibility, sir?
Yes.
His case, Shamim's case is only that. The
Yes, my lord.
Peshkar, the bench clerk, how if you bench clerk, you
Vital
put
post.
him on contractual. The file will not be there. If the file is missing, whom will you?
Take the
Lordship.
In fact, when I was there in the recruitment committee, one notification was issued by the government of Tamil Nadu saying that the night watchmen in all district court and court complexes throughout the state should be contractual. We put our foot down. Then we appealed to the chief secretary. Madam came for a meeting along with finance secretary, law secretary, PWD, everybody. Then we said the night watchmen, they are assigned 8 hours duty by rotation. And this post has been created whenever the courts were created in India. And asking us to, if suppose there is going to be a person who's a sanitary worker or a sweeper or a gardener who's got only 3 hours or 4 hours duty in the morning, that we can understand if it is contractual. Here, entire workforce is contractual. And you, apart from that, you got the civic volunteers. They are also contractual. This is going beyond, sir. This is going beyond. And you are sitting tight on the recruitment. You are sitting tight on the recruitment. That's what we told Mr. Samim. His relief sought for in the association is perfectly justified. Order passed by the learned single bench staying the notification person. But still, as an officer of court, we have appealed to him to give a reasonable solution. How will the district judge function? He is so scared and engaged Prana and filed this writ petition appeal where there is no stay of that concern notification at all. Though there is a prayer at page 77, 73. You come forward with something, sir. This is, I am not able to handle it in the administrative side. We are just forwarding with the recommendation. I write 4 lines. That line is repeated by the Registrar General Madam, forwarded to Judicial Secretary, forwarded to the MIC in charge, then taken to the Honorable Chief Minister level, then it cabinet decision. So many issues are there. But when do you draw a line for this? If suppose government leader's office, you have got your clerk, you have got your peon, you have got a group, some other person. If all of them are contractual, one fine morning you come and open the door, none of your files are there. What will you do? This is contractual employment is not the rule. It is an exception. It's an exception where we cannot do anything. In fact, Mr. Samim, what we can do is, in respect of the other notifications, probably if we get an assurance from the government leader, that the learned single bench will say that within 6 months, 8 months, we will complete the recruitment. We can make the contractual appointment with that rider for a period of 8 months, 6 months, subject to the outcome. And we will give liberty to the contractual appointees to participate in the recruitment process.
May I suggest one thing, my lord?
What generally happens, my lord?
May I suggest one thing, my lord? Because of that, why this association is come forward? Because of that, most of the posts are promotional posts from the feeder post, my lord. My lord is well aware. The fact is that, my lord, there is.
I am too well aware. I am too well aware. I don't want to say anything because we are on live streaming. I don't want to utter all those things.
Yes, sir.
I am too well aware of what's happening.
Yes, my lord.
This inter-court appeal by the learned district and session judge, North 24 Parganas and another, is directed against the interim order dated 31/7/2024 in WPA 163/17 of 2024, which writ petition was filed by the West Bengal Courts Employees Association. The learned counsel appearing for the appellant would submit that by virtue of interim order granted, the appellant is unable to proceed further with the notification dated 26th of February 2024, insofar as it concerns the district of North 24 Parganas. As could be seen from the impugned order, the learned writ court had elaborately, the learned writ court, even at the interim stage, has elaborately considered the submissions, where the correctness of the notifications dated 28th February 2024 and 14th March 2024 and granted an interim order,
Gotcha.
um, uh, directing that no further steps can be taken in terms of the two employment notifications dated 28th February 2024 and 14th March 2024. Further, it was clarified, full stop. Further, it was clarified that any steps taken in terms of the said two notifications till the date of the order, that is 31/7/2024, shall abide by the result of the writ petition. Full stop. It was made clear that any engagement made in terms of the said two notification shall not create any equity in favor of the person so engaged. The learned writ court also also fixed specific timelines within which affidavit and opposition has to be filed and reply to the said affidavit. Thus, it is seen that the recruitment to be made pursuant to notification dated 26 February 2020, appeal stand disposed of with the said clarification.
Gotcha.
So, on the larger issue, the court expressed its concern not only to the learned advocate for the appellant, but also to the learned government pleader and also to the learned counsel appearing for the writ petitioners. The grievance of the writ petitioners prime facie appears to be correct, since promotional posts are sought to be filled up by contractual engagement. It cannot be disputed with the state government that courts confidentiality and safety of records are primordial in the courts in the country. By making contractual appointment, that too in vacancies which have arisen in the promotional post, it will demoralize the workforce who aspire and desire to be considered for promotion to the higher post. It is not clear as to why the state government has not commenced the recruitment process. In fact, this has also been noted by the learned single bench in the interim order dated 31/7/2024. However, keeping these issues open, as a High Court, we are also concerned about the plight, about the difficulties faced by the learned district judges and other judges in the various judgeships in the state of West Bengal. The situation in the High Court is no better. Contractual engagement / appointment can be made in exceptional circumstances where there is genuine difficulty in not being able to fill up the posts which are sanctioned posts. Apart from that, periodical review of the cadre strength is required in every establishment, more particularly in the court establishments. Whenever proposals are sent for creation of posts, invariably the reply received by the High Court from the state government is granting permission to fill up the permission for contractual appointees. This trend is not appreciable. In any event, all these issues will be thoroughly adjudicated in the writ petition, and we direct the respondents to strictly abide by the direct the respondents to file their affidavit in opposition not later than 13th of September 2024. Reply, if any, within 20th of September 2024. And in terms of the liberty granted by the learned single bench, the learned counsel for the petitioner can mention before the learned single bench for early listing of the writ petition.
No.
With the above observation, clarification, the appeal stands disposed of. Thank you, sir.
Grateful, my lord.
Grateful, sir.
Grateful, my lord.